Obtaining a European Account Preservation Order. The nature of the procedure. The procedure for obtaining a European Account Preservation Order is ex parte so as to ensure that the debtor does not have warning of the creditor's intentions before the order is granted and to prevent the removal of funds by the alerted debtor. The order always has to be issued by a court. The court proceeds in principle on the basis of written evidence produced by the creditor in or with the application. If the court requires further evidence from the creditor, this is to be in documentary form. The court may hold an oral hearing of the creditor, experts or witnesses including through the use of communication technology. When issuing the order, the court is bound by certain time limits which are specified in the regulation. Conditions to be satisfied by the creditor. In all cases, the order will only be granted where the creditor has submitted sufficient evidence to show that their claim is in urgent need of judicial protection. The creditor has to satisfy the court that there is a real risk that the enforcement of their claim would be impeded or made more difficult if the order were not to be issued. Where the application is made before the creditor has obtained a judgment, they must also satisfy the court that they are likely to succeed on the substance of the matter. A recital clarifies that enforcement may be impeded or made substantially more difficult because of a real risk that the debtor may have dissipated, concealed, or destroyed their assets, or have disposed of them under value to an unusual extent or through unusual action. The fact that the financial circumstances of the debtor are poor or deteriorating should not in itself constitute sufficient ground for the issuing of an order. However, the court may take these factors into account in the overall assessment of the existence of the risk. The provision of security. The court may require the creditor to provide security as to ensure that the debtor can be compensated at a later stage for any damage caused to them by the preservation order. The court should have discretion in determining the amount of security. In the absence of specific evidence as to the amount of the potential damage, the court should consider the amount in which the order is to be issued as a guideline for determining the amount of the security. In cases where the creditor has not yet obtained a judgment, court settlement, or authentic instrument requiring the debtor to pay the creditor's claim, the provision of security should be the rule. However, the court can exceptionally dispense with this requirement or require the provision of security in a lower amount if it considers that such security is inappropriate in the circumstances of the case. For instance, if the creditor has a particularly strong case but does not have sufficient means to provide security. In cases where the creditor has already obtained a judgment, court settlement, or authentic instrument, the provision of security should be left to the discretion of the court. The provision of security may, for instance, be appropriate where the judgment on which the European Account Preservation Order is based is not yet or only provisionally enforceable due to a pending appeal. Procedure and time limits. The application is to be submitted using a form to be established by the Commission. It is not necessary for the creditor to give exact details about the account or accounts to be preserved, such as the account number or numbers. It is sufficient for the creditor to indicate the bank or banks where the account or accounts are held. The application and any supporting documents may be submitted electronically if this is permitted by the procedure rules of the member state where it is lodged. Depending on the circumstances, various time limits apply to a decision on the application for European Account Preservation Order. Where the creditor has yet to obtain an enforceable title, the court issues a decision by the end of the 10th working day after the lodging of the application. Where the creditor has an enforceable title, the decision is to be issued by the end of the 5th working day after the application is lodged. Where there is an oral hearing, the decision should be issued within 5 days of the hearing date, and similar time limits apply to the decision as to whether the creditor should find security. If the creditor is obliged to do so, the decision on the application for the European Account Preservation Order is to be issued as soon as the creditor has provided the security ordered. Access to information about bank accounts. As set out above, the creditor does not need to have their debtor's account numbers, but the names and addresses of the relevant banks are sufficient. If the creditor does not know with which bank the debtor holds an account in a certain member state, they may avail themselves of a special procedure for obtaining information about the account or accounts of the debtor by making an application to that effect to the court with which the application is lodged. Normally, this procedure to obtain account information can only be used if the creditor has obtained an enforceable title, either a judgment, court settlement, or an authentic instrument requiring the debtor to pay the claim of the creditor. If they have a title which is not yet enforceable, they can apply to obtain account information only if the amount to be preserved is substantial and the creditor can show that there is an urgent need for that information because there is a risk that without this information, their position might be jeopardized, and that this could consequently lead to a substantial deterioration of their financial situation. In order to avoid fishing expeditions, the creditor has to substantiate why they believe that the debtor holds accounts in a given member state.